Alberta, as a member of the St. Joseph County Bar Association committee that helped organize the local practice seminar, I just want to thank you for your attendance here today. There's a few announcements that I am supposed to make. So first of all, please remember to fill out the blue certification, CLE certification form today and turn that in before you leave. In order to receive your CLE credits, this form must be filled out and turned in. Also, as a courtesy to our speakers, could you please silence your cell phones, especially since Judge Leichty is going to be speaking. We probably don't want to be interrupting him. All right. Also, the network Wi-Fi password, or the network itself, is going to be H Honors. So that's HHONORS. And the password, 1981. Okay, so hopefully you all can get connected there. I'm going to go ahead and kick things off. I have the distinct pleasure of introducing our first speaker today, and that is the Honorable Damon R. Leichty, the United States District Court Judge for the Northern District of Indiana. Judge Leichty received his bachelor's degree, summa cum laude, from Wabash College, his Master of Letters degree from the University of Aberdeen in Scotland, and his Juris Doctorate, cum laude, from Indiana University Maurer School of Law. Judge Leichty's legal career began here in South Bend when he joined the offices of Barnes & Thornburg, LLP, and from 2001 to 2003, he clerked for District Court Judge Robert L. Miller, Jr. He then returned to his trial practice at Barnes, and whereas a partner, he represented clients in more than 30 federal and state jurisdictions across the United States, litigating primarily in products liability, contracts, and warranties. Judge Leichty also has served as an adjunct professor of law at the Notre Dame Law School since 2017. In July 2018, Judge Leichty was nominated by President Donald Trump to fill the position that he had once clerked for in the Northern District of Indiana. And on July 10, 2019, the U.S. Senate confirmed his nomination. As a recipient of multiple awards himself, Judge Leichty tries to honor the generosity of others by giving back to the community through his service on several nonprofit boards. He is also the past president of the Robert A. Grant Intercorp. So today, here to present a presentation entitled Lights, No Camera, Action, Courtroom Lessons and War Stories. Please help me welcome the Honorable Damon R. Leichty.
Good morning. Good morning. We can do it a little bit better. Good morning.
Good morning.
There we go. There we go. Thank you for having me, Shanda. Thank you for the kind introduction. A courtroom never works the way you see it in the movies, and yet there are already some things that you see, or that I have seen, that indicates to me that sometimes the courtroom is stranger than fiction. We're going to start with a little of that.
I got this video queued up in the cloud. I have not had an opportunity to watch this yet.
Are we showing it on the screen?
No, I'm going to do it directly from this guy. So, as you can see here, my client showed up for work on the day of the incident, and this is, just a sec. I'm going to have a talk with my next guy.
Whoa.
You know what?
I want to see it.
The video is not.
Show it to me.
It's not working. I don't understand.
Is this what the jury just saw? That's the whole thing?
Unfortunately, yes. That is not what the whole thing was supposed to be.
Not only was the animation so poor, but it glitched and just froze up. So again, we only saw like 5 or 6 seconds worth of video. But it was crazy. It was absolutely crazy.
It's like the defendant is getting hosed.
He's showing very clear frustration. He's banging his hands on the table when his attorney can't present a simple video. It's a hot mess, to say the least.
Before I let you go for lunch,
All right. You would think we don't see that type of performance sometimes in the courtroom, but occasionally we do. Technology, of course, is always a challenge, but there are always surprises, and I'm fond of telling my law clerks, I never know what I'm going to do or have to do on the bench because we never know what exactly is going to happen. Take, for instance, a recent wrongful death trial that we had very skilled counsel on both sides. It was a hard-fought case throughout. We presented the case, tendered it to the jury. The jury is deliberating a verdict. The parties go off and they settle the case. And they call chambers and they say, hey, we've settled the case. Jury verdict hasn't come back yet. Bring the lawyers back into the courtroom. We proceed to put the terms of the settlement on the record. And as we are doing that, the U.S. Marshal comes in with a piece of paper. And lo and behold, sure enough, it's the verdict. So here are the lawyers. They have just settled the case. They see the verdict come in, and they're all looking like a curious bunch of cats. What is the verdict? Have I settled well? Should I be settling at all? Did I settle poorly? And for my part, well, there's no rule, there's no law that tells us exactly how we're to proceed, right? And so I just take the verdict and I don't look at it and I promptly turn it face down. I didn't want any rake in the poker face as to what the verdict amount was. I complimented the lawyers for deciding their own fate, complimented the clients for doing the very same thing, and that's just the joy of trial. As much preparation as we see to, as much preparation as we all undertake, both as the bench and counsel and parties, we just can't always write these stories. Sometimes life in the courtroom is just stranger than fiction. I'm going to provide, hopefully in the course of today, not just some movie clips, but also some tips. A couple years ago, I did a similar presentation, but I focused on more pre-trial. This is going to be focused as much as possible on trial tips for the trial lawyers in the room. All right, just briefly, and I'm not going to spend a lot of time on laying the landscape or on statistics, but here are the statistics both for the Northern District and the Southern District of Indiana on the number of trials that have occurred. Obviously, you see a rather stark dip at the beginning of the pandemic and then an upward climb from there. So in 2020, we had only 10 trials. In 2021, at least here in the Northern District of Indiana, that climbed to 24. Rose again the following year to 27, and we're on pace then to exceed that as well. And what's notable in part about this, that's with fewer judges, right? We have 2 vacancies in the Northern District of Indiana. We're very hopeful that we have 2 nominations that come soon because the number of cases spread out among our 3 active judges and our senior judges are rather tremendous. So we're seeing some good trials. I've seen some defense verdicts. I also had a plaintiff's verdict of over $100 million in an insurance coverage action. That's, I think, one of the largest verdicts in the Northern District of Indiana. I won't comment any more on that case because there are still things working through the system, but we're seeing a great variety of trials and very skilled counsel in all of these trials. Number of total civil cases filed. Again, you see this sort of natural dip from the pandemic and then an increase this year to over 2,200 civil cases filed. And then likewise, you see our trend line where these civil cases continue to increase as a general matter year over year. In terms of the status of pending civil cases, you'll see the commenced and terminated numbers there. Probably the notable number as of September of this year is that we're near 2,000 pending cases. And as you know, again, those are largely divided up among the 3 actives and then as well as our 5 senior judges. So we are tremendously busy and we do thank counsel for helping us to make these cases as efficient as we can. All right, as a trial lawyer. I was a trial lawyer. I remember the days. I would always want to know, in representing clients, how long a judge or a district might take to rule on a particular motion. Then you can go to your client and you can say, look, on average, this is how long you might wait before you receive a ruling. So over the last 12 months, there have been 276 motions to dismiss. 65% of those have been granted, at least in some measure, or in whole. And as a district, it takes about 52 days for a ruling to come out. That has actually decreased fairly substantially year over year, and so we're seeing some traction, I think, in terms of getting those rulings out as timely as we can. Summary judgment, we'll see a longer period of time. Obviously, those are record heavy in whole. We have 364 of those that were filed in the last 12 months, 62% granted in whole or part, but 217 days, so a much longer period of time for us to, on average, get a ruling out to you all. That has actually increased year over year as compared to the motions to dismiss that decreased. So that gives you at least a sense of the workload and the turnarounds that you can anticipate as counsel for your clients. All right, let's talk about juries.
All right, ladies and gentlemen, we're going to ask you a series of questions to determine whether or not you can be impartial jurors. First off, do any of you have any prejudices you feel the court should know of? Yes, you, sir.
Ants. I hate ants.
What?
That's right, you heard me. I'm an ant hater. Just like my daddy and his daddy before him. So if this is an ant trial, forget it. No way I'm gonna be fair. Always making those cocky little hills, moving around all single file and stupid, all ganging up and walking my pie off the picnic blanket. 'Twas my pie gone missing.
Sir, this is not an ant trial.
Oh.
Is there anything else we should know about?
All right. Almost every civil case, there's a prospective juror, you've all seen these jurors too, who just cannot, in good conscience, in a civil case, put the defendant to death, right? And I have to explain to them, well, thank goodness, because this is only a civil case. We're only talking about money today. So we often have some interesting voir dire moments in the course of trial. As a quick side note, getting ready for this presentation yesterday, I was watching this clip in my office when Linda, who helps to clean the offices over there in the federal building, came in and caught me watching cartoons. And I said, well, now you know I don't do much work around here in Chambers, I just watch cartoons. Every jury that I see and have seen takes the job quite seriously. There's a reason why the right to a jury trial is enshrined in the Constitution 4 times, in Article 3, and 5th, 6th, and 7th Amendments. And the jury never ceases to amaze me as to how seriously it performs its function and its role as the primary fact-finding body of our justice systems. And I think in cases both simple and complex, my impression is frequently reaffirmed that they're taking their jobs seriously, how carefully they listen to the evidence, and how often they notice things, both big and small. Here's a borrowed story. It was a mail fraud criminal case. It involved an investment scheme, multiple defendants, 34 counts in the indictment. It wasn't a civil case. The trial takes over 2 weeks to proceed. And early in the case, the government is introducing evidence on the various acts of mail fraud that occurred. But as to one, overlooks asking the victim whether she received the fraudulent communication in the mail. And this is, of course, over the course of a long trial, as I said, involving multiple victims. But one of the jurors catches that the government, as to that one count, omitted that piece of evidence, and the jury acquits, which leaves everyone wondering, why would they render a guilty verdict as to all the other 33 counts, but an acquittal on that one count? Well, it's very simple. out of all the evidence that had been presented in the course of the trial, in a very complicated scheme, the jury caught the absence of proof, and that's been my experience. In another civil case, there was a husband and wife who had claimed that an insurer had underpaid for fire loss to a home and for the expenses that they had incurred when they were displaced from their home. And the insurer claimed that the couple had submitted a false lease and some other false claims, false expenses. And of course, as you all know, there was a concealment and fraud provision in the insurance policy that would undo coverage. So evidence is presented on these points, both pro and con. And though none of the questioning from or of the witnesses really tended to focus on the nature of the documents and the signatures that appeared on the documents. Instead, they were focused more on what the husband had done. He was the primary driver, the primary communicator of the claim, but not the jury. The jury was just as much focused on what they were seeing on the documents, whether questioning pointed that out or not. And they remarked later that they had noticed that the wife's signature always seemed to change document from document, even though there had been no questioning to point that out, as though they seemed to think that that was rather unauthentic. So, again, what's this tell us? The jury as a whole may not see everything in the course of a trial, right? But there are 8 jurors or 12 jurors, depending on the nature of the case. And more than likely, at least one is going to catch something that matters, and of course they will collaborate. So if as trial lawyers you're wondering, hey, do juries get it? Will they understand the nature of the cases? My experience has been yes, though it's absolutely essential to present a very clear case, a People's Magazine version of your case, to be very efficient. The jury system works tremendously well in identifying and examining the evidence to reach a fair and just verdict. A couple tips in federal court. We've learned some new tricks of the trade as a result of the pandemic. I hate saying the word pandemic, but it's true. In the old days, you used to have to come over to the clerk's office to examine the juror questionnaires before trial. Many of you have done that. We now use a software called Digify. So if you're trying a case in federal court, you get the luxury of receiving a link, a computer link, from our staff, which gives you access then to the juror questionnaires during a certain window of time. The software has natural protections built in, so you can't print or otherwise reproduce the juror questionnaires. I suppose it doesn't prevent anybody from taking a snapshot with their phone, and so I include I allow for that use of Digify with the proviso that no one image or photograph the juror questionnaires. So that's a benefit that we have seen with respect to juror questionnaires. On voir dire, I often get the question, will you let lawyers conduct voir dire? The tradition in federal court has, of course, been that federal judges often conduct the bulk of the voir dire, and I still see to that. But in a civil case, I will let trial lawyers conduct their own voir dire. I'm not going to give you a long period of time to do that, but I will give you some time to ask follow-up questions should you wish to do that. And of course, our juror questionnaires cover a lot of material. The court will cover a lot of material too, but that at least gives you some flexibility to ask questions as you would like. So that is an option, at least in my courtroom. Any questions on juries, voir dire, Digify? No? All right.
Guy put a gun on me. I put mine on him.
Yes, the issue here. There isn't self-defense.
So what's up?
Absolutely.
Go ahead. Didn't have a gun.
He'd be dead.
Gun?
Fini.
I had to shoot.
Oh,
Saved my life.
And Jared's.
Didn't shoot to kill.
Just a wound.
Took a knee.
And 2 feet.
Boom.
Boom.
And boom.
Objection! Hey, this is funny.
Funny. Did you have a chuckle the last time somebody pulled a gun on you?
This case is about concealing a handgun on the person, not about self-defense.
That doesn't mean we can ignore the reality that if Mr. Crane didn't have his concealed weapon,
Dang.
gone.
Hey.
Boom.
Boom.
And boom.
Objection! Stab it!
All right. I'm not here to teach Shakespeare, and I'm not here to invite you to turn my courtroom into a scene from Boston Legal or Suits. That said, there's so much emphasis that's placed on the testimony and evidence, as it really should be, of course. But I want you to be mindful, too, of what I call the theater of the courtroom, the stage work, the scenery, what's happening in the courtroom aside from what the witness and lawyer are saying in front of the jury. And the jury, I assure you, notices all of that, too. We had an excessive force case in which 2 officers were sued, one for using excessive force and one for failing to intervene in that excessive force. The force was used on an intoxicated individual on New Year's Eve in a detention facility. And the video was really the centerpiece of this trial. And at first, the jury as a whole, when they first saw this video, they were absolutely glued to the screen, focusing on what transpired over the course of this evening. And then as the video played, both the first time and later when it was played again in the trial, a few members of the jury not just watched the video, but they started watching the officers. And one of the officers, the one who was alleged to have used excessive force, often found himself wanting to chat with his colleague at counsel's table. And the one who is accused of failing to intervene wants nothing to do with the one who's accused of excessive force. And he's focused on the video, he's very quiet, he's very much watching the screen, while the other one is having a reaction to what is playing on the video. And the jurors are seeing that. The jurors are not only watching the video, but they wanted to see very clearly how did these 2 officers react to seeing their own conduct. Now, perhaps everyone else in the courtroom saw this transpiring too, but I can assure you the jurors were not overlooking that particular aspect of the trial. Here's the point. The evidence and the testimony absolutely matter, and they matter most, but let me encourage you to also think strategically, pragmatically, about how to present the characters that you're writing for the jury, and in the context of what is, at times, the theater of the courtroom. The jury may sometimes see the mundane, right? They may see the funny socks a lawyer wears, or a particular tick of a witness, or something else that's idiosyncratic that doesn't really matter to the case. But they're also focused particularly on the testimony and the evidence, what is said, what is shown, but they're also focused on what happens in total in the courtroom. So be mindful of the fact that the jurors are really students of human behavior, and they may be watching your clients, they may be watching witnesses, they may be watching lawyers, even when they're not actually in action. So be mindful of that as you present your cases.
Guy pulled a gun on me.
All right. Real quick, I'm not going to get too much into briefing this morning. I really want to focus on pocket briefs. Have you all heard the term pocket briefs? Anyone ever used the term pocket briefs? Anyone use pocket briefs at all in trial? Okay. This is something a little bit new, perhaps. You might call this a motion in limine's little brother. A trial not long ago reminded me of this sound strategy. Essentially, pocket briefs are an effective way to raise an issue without delaying trial, or asking the court to rule without the benefit of at least some modest briefing. So it's a short brief. I use these when I was a trial lawyer. I see these now and again too. Think of them as a 1 or 2 pager. Forget and suspend the local rules that govern formatting. Don't think of this as, well, I need to have this double-spaced, 1-inch margins, and so on. Think of it as an executive summary. So this is something that you could work outside the box. It could be bulleted. It could be, very short presentation. It might have images captured as part of the presentation. But it's something that allows you to pull it from your pocket, and when a particular issue that you anticipate is going to arise in the trial, that's going to be rather key, it allows you to be prepared, show that you're prepared. It allows you to present some authority to the court should you need it, and it often can facilitate a ruling aside from preserving any issues for appeal. So again, there's a recent trial, an issue that seemingly had arisen between the parties in the overnight hours. Of course, the court is unaware of that until the morning. And so when I took preliminary matters up in the morning, one of the parties brought the issue to my attention and provided me a very short pocket brief, briefly outlining the issue and the law. Now, this is the first time this issue has ever been raised, first time that it's ever been anticipated in the course of the trial, at least seemingly so. It helped frame the issue as I could review it very quickly on the bench, and then it allowed us to get to a ruling promptly so the case could continue on. In another example, there was a rather serious criminal case. It was a sex trafficking of a minor case, where the lawyers knew there was going to be an issue that would precipitate a lot of objections back and forth as they questioned an individual witness. And how did they know that? The good lawyers in this case had met and conferred about the testimony that was going to be presented the next day. Now, there happened to be a very key Seventh Circuit case that laid out a 4-part standard that I had to apply in working through those particular issues. And they didn't really need to present me with a pocket brief. They just said, look, Judge, here's the case. Here are our respective positions, both prosecutor and defense. This is what you're going to hear. We're just arming you for what's to come. And I found that to be quite helpful as we work through a very complex area of the law and a very sensitive area with respect to testimony. Now, trial judges, and there's some here in the room too, we get things thrown at us regularly all the time, and we don't need pocket briefs on every little point, certainly. But if it's something that's going to be substantive, very meaningful, if it's going to be something that you think would help frame the issues or facilitate a prompt and accurate ruling, then think about these pocket briefs as a tool of the trade. Outside of that recommended practice, let me just emphasize a couple things that I think would be helpful just from the bench's perspective and also the law clerks who assist. Efficient briefing is always valued, is always encouraged. I teach product liability at Notre Dame Law School, and I have a class on Daubert, and I teach the students all about motions to exclude under the Daubert standard. I then make them draft a Daubert brief. You want to know how many pages I give them for a Daubert brief? 6 pages. Now, you're used to the luxury of 25 pages in federal court. And they always ask me, why are you making us draft this in 6 pages? And I said, because it can be done. And you can often boil down arguments to their very essentials in a way that's still persuasive, it's still complete, but it's also very tight, concise, and cogent. So don't run with the page limit just because it's there. On occasion, we will see briefs that are filed without pin sites to the record, and some of these records, particularly on summary judgment, can be rather mammoth, and that makes our jobs, of course, more difficult. It also takes more time for us then to rule. So to the extent you can pin cite the record, that will allow us to get a ruling out more efficiently. The other one that I want to emphasize is don't bury the evidence. We will get records filed en masse. So, together it might have emails and invoices and then pages of a transcript or sort of mixed exhibits. separate those exhibits out and be as organized as you can in terms of the record, and that will help us as well, if you could be so kind. Questions on packet briefs? All right. Well, to the extent those opportunities come up, don't be afraid to work outside the box with respect to pocket briefs. All right, we're going to talk supplemental disclosures here.
Second. Well, let me look at it. It's fine, but, maybe he'll relax enough to drop his guard so that I can finesse a little information. Sure like to get a look at your files.
Would.
Sure.
You got Xerox machine over there?
No.
Oh, that's okay. I'll have the secretary do it. Shirley, can you Xerox all the files on the Gambini, Rothenstein case for Mr. Gambini? Yeah. Thanks, sweetheart.
What's all that?
Trout his files. All of them.
You stole his files?
I didn't steal his files. Listen to this. I'm just ready to finesse him. I'm starting to finesse him, right? I got it going. He offers to have his secretary copy everything for me.
That's very impressive, finessing.
That's not all. He's letting us use his hunting cabin as soon as he gets back. It's in the woods. It's quiet. He sleeps like a baby when he's there.
Terrific, you're out of a bundle.
What's this? You reading this book?
Yeah.
Do me a favor, okay? Don't read this book. Okay? Thank you very much.
All right. Do you want to know why he's truncating his files?
I told you why.
He has to. By law, you're entitled. It's called disclosure.
We had to strategically cut out that last word. You've all seen the movie, you know what she says. In federal court, you don't have to do as much finessing, right? There are all kinds of disclosure rules that exist. And it may be that with some dearth of trials that the practice of supplementing disclosures has become rusty, and I want to try to reframe or reemphasize that approach. And probably as soon as I say supplemental disclosures, you start to glaze over. But bear with me here as I share a couple war stories as to why this is important. First, just by way of brief background, Rule 26, of course, requires you to disclose witnesses, exhibits, computation of damages. You all know that. There are initial disclosures under 26A1, and then, of course, 26E requires you to supplement your disclosures if they are inaccurate or incomplete or incorrect in a timely fashion. Failing to supplement disclosures could be a really major thorn. And I'm not going to comment today on the merits at all, but I have seen parties disclose on the eve of trial 5 witnesses on a particular defense, knowing all along that that defense was a key issue in the case. I have seen a plaintiff on the eve of trial want to amend their damage claim by $14 million because they had not disclosed a rather large subset of their damages in comparison to prior disclosures of other damages. And I've also seen the newly created or newly disclosed exhibits either on the eve of trial or recently even on the very last day of trial. Now, you all know that Rule 37 may allow these things if it's substantially justified or harmless, right? And the court, of course, will run that analysis faithfully when these issues arise. But my experience has been if the parties could just be modestly more diligent about their supplements, that many of these issues just would not arise. Here are my suggestions as you think about supplemental disclosures. And in giving these suggestions, I'm going to, again, harken back to the fact that I was a trial lawyer once. I know how this works, right? You'll get a scheduling order from the court. You'll schedule all the hard deadlines, and the supplemental disclosure deadline, which we include as every 6 weeks throughout the case, you all will consider that a soft deadline. I understand that as well. Let me try to reframe that, though. When your team calendars the deadlines from the scheduling order, calendar these supplemental disclosure deadlines. Go into your calendar and do a periodic disclosure deadline. And do that not just during discovery or when summary judgment has now hit the docket, but schedule that on through trial, or at least until you get a ruling on summary judgment, so that you know whether you are going to trial or not. And do that even if it's not court ordered. More than that, create this document as an organic document. So when you do your 26A1 disclosures and you have your list of witnesses, you have your list of exhibits, you also have your computation of damages, that's an organic tool, right? If you identify 5 more witnesses and a few more documents, well, then all you have to do is briefly add that to your original disclosure, re-entitle that as supplemental disclosure, a first, a second, a third, and so on, and send that out. It really is not a burdensome task in that respect. And then, if unforeseen or new needs arise, we'll disclose things immediately. I did have a case recently where on the last day of trial, the morning of, counsel came, very, very good, skilled counsel, came in and said, Judge, we identified, there were massive exhibits in this case, we identified an exhibit that we just hadn't put our thumb on at any other point in the 2 years leading up to trial. And we really need to use this exhibit this morning. And I said, all right, well, explain to me the circumstances as to how you identified this exhibit. And they proceeded to tell me, which included the fact that they had identified the exhibit the night before. Now you know which question is coming next, right? Did you tell the other side last night when you identified the exhibit that you needed to use it? No. When did you tell the other side that you needed this exhibit? They're finding out right now. Right? Well, you can probably anticipate just from that discussion how the analysis starts to naturally work out when that exhibit then gets excluded in the course of the trial. So, if you follow these tips with respect to supplemental disclosures, I think at the end of the day, what you'll find is a rather helpful refrain that you can use with the court. Look, Judge, we supplemented our disclosures 5 times, 6 times, 10 times. And whatever small gap then that remains in the course of those disclosures, well, that was entirely known through some other mechanism, or it's at least harmless. So continue to think, even when you're in the throes of discovery or motions practice, continue to think as a trial lawyer. Continue to keep your eye on that end game. And my experience then is if you just spend a little extra time, maybe just a little extra money, that modest cost will ultimately return great dividends as an investment when you ultimately get to trial. Questions at all about supplemental disclosures? All right. Do people follow that practice? Is that customary, or is that something that Libby says, yes, I do it all the time. Anyone else? Yeah? No? All right. Well, give that some thought. I think that's a helpful tip leading up to trial. All right. We're going to talk experts briefly.
Would you be interested in testifying for me as an expert witness?
Yeah. Oh, yes, I'm in. I get to go up on the stand and perform in front of all these people.
No, not really. Could you state your name for the court, please?
My name is Slim Shady.
Now,
Are you joking? I mean,
please just state your name for the jury, please.
Andre knows it.
Dr. Andre Nozick.
Okay.
And what is your profession?
I am a expert witness.
That's not your profession.
I am a plastic surgeon.
Put your hands away. Don't holster them. Don't holster them. Would you mind taking a look at the exhibits over there? You can see photos of the plaintiff.
Okay, hold on a second.
Photos of the plaintiff before her car accident and after her accident. And how would you say the plastic surgery is?
Surgery is excellent. It's very natural. And one would wonder what she looked like as a little girl.
I don't think we need to wonder about that. I think you take the glasses off that they're making you look like a total idiot. So you've written a number of studies, isn't that true?
90% of women
Why is he sweating like that?
who are affected by plastic surgery are oftentimes in better relationships.
So I have no further questions. I'm done with this
I
question.
can stay.
Please sit down.
All right, we typically see experts who are a little more polished than this. Tips of the trade here for experts. We could spend a lot of time on the Dauber trilogy and 702. All I'm offering here is, in effect, what I hope to be a rubric that you might use to understand and then apply Rule 702. Now, you all know that under the Dauber analysis, it is a flexible inquiry, right? So I don't mean this rubric to be a straitjacket. I simply mean it to be a helpful lens by which you can get into expert testimony. And that can be true whether you're taking a deposition of a particular 702 witness, whether you are cross-examining the 702 witness in the course of trial, or even before then, whether you're filing a motion to exclude under Rule 702 and Dauber. So in that orange box there, that's really the language that is already written into 702, and then off to the right, I've offered what I intend to be this sort of helpful rubric to understand and assess expert testimony. So every expert has to have an opinion, right? The expert has to have credentials. That can be something that is educational driven or something that's done by way of training. There's lots of ways to develop expertise. There has to be a factual basis, what we call sufficient and known facts. There has to be some sort of validation, or at least that's a factor to consider in the analysis. What do we mean by validation? Well, if you recall your Dauber trilogy, that includes whether something's been tested, whether it can be tested, whether there's peer review, what the error rate might be, general acceptance. There's lots of different factors that go into the validation inquiry. And then there has to be what is the more nuanced inquiry of fit. Does this particular opinion help the trier of fact decide an issue of consequence? Certainly if an expert ticks off most all of those boxes, the likelihood is that 702 opinion testimony is going to be admitted. To the extent that an expert tends to fail those inquiries, then the greater likelihood is that the opinion will be deemed inadmissible and barred from trial. So consider, those sort of categories, if that's a helpful mnemonic. Again, as you're taking depositions, cross-examining a witness, or gearing up on a motion to exclude. I suppose this gives you some insight into my lens, too, on how I go about deciding Dauber motions. So I will often think of 702 in these categories, given the way the rule is written. All right, questions on Dauber? Yes, sir.
Do you have any suggestions at this point in time with regard to the upcoming changes in 702?
Yeah, so we are going to talk about those this morning. There are two changes in large measure to 702D, which goes into effect December 1. So 702D is that, in part, that last category, last two categories really. They changed the language in 702D in a way that says that rather than the expert has reliably applied principles and methods to the case, it now says that the expert's opinion reflects a reliable application. of those things to the facts of the case. I've not seen the advisory committee notes to really get into why that change was made. I think functionally, that will probably have little difference day to day in what lawyers and judges do with respect to 702D, that part of the inquiry. I think the emphasis is that the opinion, not just that the expert has done this, but the opinion as disclosed, appreciating that there is a disclosure requirement under Rule 26, that opinion has reliably applied those principles and methods to the issues in the case. The other change is really one that most all federal courts, and certainly the federal courts here in the Northern District of Indiana, have already been following since Joyner, but it simply encapsulates within the rule that the standard is a preponderance. The person who wants to propose the 702 testimony has the burden by a preponderance to establish its admissibility. The rule now memorializes that burden. There were a couple stray courts that were sometimes using language that was maybe not quite as pure in meeting that particular standard, and so it seems the committee wanted to make sure that that was understood. But I think for most all of you, and certainly for the courts here in Northern Indiana, I don't think the changes to Rule 702 are going to have a functional difference to your day-to-day or to ours. There's another question. That was a question you had too, Candace? Okay. Of course, I've got a few more weeks before that rule takes effect, so don't take that as an advisory opinion.
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case! Good call!
I don't get too many good calls, but sometimes I get some whys. But quick tips here for in-trial techniques. Obviously, know your federal rules of evidence, right? That's a given. Particularly, and this is something that I'm seeing struggles with more than I envisioned I would. The distinction between impeaching a witness and refreshing recollection. Now, those are so formulaic in many ways for trial lawyers, right? It's more of a rote exercise. But it's not infrequently where I have to ask counsel, are you impeaching a witness here, or are you refreshing recollection, right? Do you get the opportunity to read the testimony from the deposition because you're impeaching a witness, or you just need to let the witness read it because you're refreshing recollection? And sometimes that gets mixed. So, no pun intended here, but refresh your recollection as to the distinctions between those two. Understand that when you're impeaching a witness, if you get an answer, you need a definitive answer before you can impeach a witness, right? You can't get an answer that says, from the witness that says, well, I don't know, or I'm not sure. To the extent you get those answers, you've already succeeded in really what you want to do. You've shown the witness to be less than sure or less than certain about a particular fact. There's really no need to go on then to impeach the witness. So first, ensure that you get that very clear contradictory response before you go about impeaching a witness. And if you see a lawyer on the other side who is not following the protocols, well, then don't be afraid to object as to a proper impeachment. Sometimes that goes unnoticed as well. Closings, I've seen some tremendous closings recently. My only tip there is don't read them. These are good people, right? They've devoted their time to the trial. Talk to them just so. Pace, slow down. I know we all get in the groove sometimes, and occasionally we will overtalk a witness or overtalk counsel. Or to speak too fast. Remember your court reporter. Remember this is your record that you want to have preserved and clean in doing so. So just let me encourage you to be cognizant of your pace. With respect to staff, not only be courteous to the staff in the courtroom, and as a general rule, as I look out into the crowd, you all are. The judge will obviously know if you're not, so be thoughtful of that. But also be kind to your own staff. In a recent trial, there were some technological issues with the exhibits that were on the computer. And this paralegal that was in the trial was working tremendously hard to get everything done correctly. And there was certainly no fault of hers that there were any issues with the technology. But the lawyer was getting a little bit cross with his own staff, and that was just coming off in a way that you would not want it to come off in either in front of the court or in front of the jury. So just be mindful of that as well.
Now, Mr. Cheeseman, is it? Cheeseman. Or motion to dismiss based on?
Rule 11, Your Honor, specifically on the fact that Mr. Schlickman had absolutely no evidential grounds on which to bring this suit. Only his knowledge that my client, the WR Race Corporation, has a lot of money. Not true. He performed no real investigation. He did no research of any consequence, except perhaps to review profit statements. And he's prepared his complaint so inexpertly as to render it moot.
All on him.
Do you know what Rule 11 is, Mr. Strickland?
Well, to be honest with you, Your Honor, I had to look it up.
I'll be honest too. So did I. Do you know why, Mr. Cheeseman? Because it is so old and ambiguous. Few lawyers waste their time with it or mine. It's a non-issue, Mr. Cheeseman. Your motion is denied. Thank you. Thank you. Anything else? That's problem.
Excuse me, Mr. Thatcher. I'd like to thank you. That was very statesmanlike of you not to join in that ridiculous thing.
You're welcome.
All right, well, know your rules, right? I still will get my rule book out on a regular basis, even if I think I know the rule by heart, and I'll review it again, because inevitably a new issue will cause you to read the rule in a unique way or with a different lens. In terms of upcoming rule changes, just to be aware of course, we mentioned the 702 change. There's two others that I think, well, three others really, that I think you may want to be aware of. There will be some changes to our local rule 56-1, the summary judgment rule, that will make some additional changes to that practice. So look for that. Those changes haven't been finalized for public comment just yet. Rule 87 was adopted in our Federal Rules of Civil Procedure. You can call this the COVID rule. This allows for the suspension of civil rules to the extent there's a need to do so because the court's ability to perform its functions are somehow impeded. Rule 106, you all will remember this rule as the rule of completeness. So if someone presents a written or recorded document, and you think that there are other portions of that writing that need to be submitted as part of that, then 106 gives you that ability to designate, additional portions of a transcript, for instance. 106 now is changing to also cover oral statements. And it also not only covers oral statements, but it also will cover oral statements that beyond a hearsay objection. So the rule actually says now, or will say come December 1, as we anticipate, that the adverse party may do so, that is, submit additional portions of the oral statement over a hearsay objection. So you want to be cognizant of that change, not only in presenting oral statements, right, to anticipate what else might be introduced by the adverse party, but also to know that that's no longer limited to a writing or recording. 615 is the separation of witnesses rule. You all have used that frequently in trials. A few changes to that rule. Obviously, it allows the court to exclude witnesses who haven't yet testified from the courtroom. It now adds that the trial court can also require counsel not to disclose testimony to that witness who's excluded from the courtroom, or to have others disclose that testimony from the courtroom. A second change to 615, in the past, the rule was written more broadly in terms of the designated representative that you have in the courtroom. It's now going to be written in a way that indicates, or at least suggests, that there can be only one designated representative in the courtroom, absent the court's permission. My practice has been already to require that designation of counsel at the beginning of trial, or for some reason someone has to be absent during the course of trial, then during the morning of trial. So be aware of those couple changes that are coming down the pike as well. Any questions on new rules? Libby?
So the notice of motions to strike, in an earlier slide you had something that said no motions to strike. Is that related to that, or is that for pocket briefs specifically? Or?
Yeah, not for pocket briefs, but in our local rules, we've eliminated motions to strike in the Rule 56 context. Right? In the old days, if you thought there was a certain portion of the record that was inadmissible, you file a motion to strike. What we find then is there then becomes this whole second tier of briefing that occurs with the motion to strike. So the local rule now requires that any questions about admissibility of exhibits within the summary judgment record get addressed within that summary judgment briefing, so it's a contained whole. So, and with motions to strike, look, you're going to have to show some prejudice with a motion to strike. Those aren't often granted, so just be thoughtful when you do think about filing a motion to strike, and by all means don't do just a kitchen sink motion to strike. Be very strategic and targeted if that really is compelled in a particular case. Any other questions? All right. Last but not least. Yes.
Stand up. My father's passed me.
I love that scene. It exemplifies respect and civility for our profession. And I'm not here to preach, I'm here to encourage. Civility serves your clients, serves you, serves opposing counsel, it serves the jury, serves the court, it fosters persuasiveness. I know we all have our moments at times, given the demands of a difficult practice. But remember, at the end of the day, that we have a tremendous tradition here in northern Indiana, throughout Indiana, frankly, of civility. And thank you for all that you do to maintain and preserve that tradition. That's all I have, unless there are other questions. Questions about trials? Anything that you want to know as a peek behind the curtain?
The officer that was accused of failing to intervene that was looking at the video, was he convicted?
Well, it wasn't a criminal case, it was a civil case.
Okay.
It was a $1.25 million verdict. It was compensatory damages against the one who was alleged to have used excessive force, and then there was a punitive damages award against that officer and the sheriff as well, the sheriff's department. The one who was alleged to have failed to intervene was found not liable.
Thank you.
Yeah. Any other questions? All right, thank you for your attention. Thanks for having me.